Another aspect of Assembly Bill 276 from the 2017 legislative session is that it makes it an unlawful employment practice for an employer to discriminate against an employee for inquiring about, discussing, or voluntarily disclosing his or her wages or the wages of another employee that employee has shared. It also makes it an unlawful employment practice for an employment agency to discriminate against any person because the person has inquired about, discussed, or voluntarily disclosed his or her wages or the wages of another person. And finally, it makes it an unlawful employment practice for a union to discriminate against a member or an application for membership for engaging in the same type of conduct we've just been talking about. Now, some quick background on where all this comes from. Most employers, not all, but most employers are subject to the National Labor Relations Act, which protects employees who are engaging in what's called protected concerted activity, meaning they are complaining or discussing wages, hours, or working conditions. So one of the things that the National Labor Relations Act protects is employees who want to discuss their wages or salary or other pay measures. Employees are allowed to do that. A lot of employers I know try to prohibit that, but that is not appropriate. Employers are perfectly allowed to discuss their wages. Now, this new law in Nevada, AB 276, makes it a Nevada law that allows employees to discuss their wages. Now, what that doesn't mean is someone with access to confidential information, like an HR professional who has access to payroll information, cannot go discussing the wages of every employee. But a single employee or multiple employees who want to disclose and discuss their wages among themselves are perfectly free to do that, and an employer cannot prohibit it.